Data Privacy Act, RA 10173, Data Privacy Act, Section 2. It is the policy of the state to protect the fundamental human right of privacy, of communication, while ensuring free flow of information to promote innovation and growth. The state recognizes the vital role of information and communications technology in nation building and its inherent obligation to ensure that personal information in information and communication systems in the government and in the private sector are secured and protected. Scope of the law: personal information controllers and personal information processors processing personal data of data subjects. Definition of terms: personal data, any information from which the identity of an individual is apparent, any information that can be put together with other information to reasonably and directly identify an individual. Includes sensitive personal information such as your health, education, genetic, or sexual life. Includes information that is classified or privileged. Personal information controller, the agency or corporation who controls the processing of personal data. The one who decides. There is control if the natural or juridical person or any other body decides on what information is collected, or the purpose or extent of its processing. Not the employee, not the data protection officer, not the chief information officer. Privileged information, any and all forms of data which under the rules of court and other pertinent laws constitute privileged communication. Personal information processor, any natural or juridical person or any other body to whom a personal information controller may outsource or instruct the processing of personal data pertaining to a data subject. Data subject, an individual whose personal information is processed. Data privacy principles: transparency, legitimate purpose, proportionality. Rights of data subjects: Number 1, right to information. Number 2, right to object. Number 3, right to access. Number 4, right to correct. Number 5, right to erase. Number 6, right to damages. Number 7, right to data portability. Number 8, right to file a complaint. Data sharing. Number 1, are you providing access to personal data you have collected to a third party? Is it under an outsourcing contract? Number 2, is there a specific provision of law that specifically requires data sharing? Number 3, if there is no specific provision of law, is there a public service and a statutory mandate? Do you have consent of the data subject? General rule: if it's not clear, it is not consent. Exceptions. Number 1, personal information. Letter A, contractual or legal obligation. Letter B, national emergency, public order, public safety. Letter C, legitimate interests. Letter D, to protect life, health, vitally important interests. Number 2, sensitive personal information. Letter A, law or regulation. Letter B, to protect life and health. Letter C, provided to government under legal mandate. Letter D, protection of rights in court. Contents of data sharing agreements. Number 1, purpose of data sharing, including the public function and public service it facilitates. Number 2, parties to the agreement. Number 3, term or duration of the agreement. Number 4, Overview of operational details and general description of security measures. Number 5. How data subjects can exercise their rights. Vote buying and vote selling. Who is liable for vote buying? How is it committed? Vote buying is committed by any person: A. Who gives, offers, or promises money or anything of value. B. Who gives or promises any office or employment. C. Who makes or offers to make an expenditure or cause an expenditure to be made to any person or association in order to induce anyone or the public to vote for or against any candidate. Vote selling is the crime of one who accepts. Who commits the crime of vote selling? Any person, association, corporation, group, or community who receives, directly or indirectly, an expenditure or promise of any office or employment, public or private, in order to vote for or against a candidate. Cyber libel. What is libel? Article 353. Definition of libel. A libel is public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. How is libel committed? Article 355. Libel means by writings or similar means. A libel committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibition, or any similar means. Cyber libel in the Philippines. Cyber libel defined. The unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code as amended, committed through a computer system or any other similar means which may be devised in the future. Elements of cyber libel. Letter A. There must be an imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance. Letter B. The imputation must be made publicly, which requires that at least one other person must have seen the libelous post, in addition to the author and the person defamed or alluded to in the post. Letter C. The imputation must be malicious, which means that the author of the libelous post made such post with knowledge that it was false or with reckless disregard as to the truth or falsity thereof. Letter D. The imputation must be directed at a natural or juridical person, or one who is dead, which requires that the post must identify the person defamed, or at the very least, the person defamed is identifiable by a third person. Letter E. The imputation must tend to cause the dishonor, discredit, or contempt of the person defamed. Letter F. The imputation was done through the use of a computer system or any other similar means which may be devised in the future. Procedure in filing cyber libel. Jurisdiction. You can file a court case for cyber libel at the RTC. To prove cyber libel, the act must be proved to be libelous and it must have been committed through a computer system. An act is libelous when the allegation of a discreditable act or condition concerning another, publication of the charge, identity of the person defamed, existence of malice. Prescriptive period. You can file a cyber libel case up to 1 year after the act. The first step is to file a complaint at the prosecutor's office, complete with the evidence. This evidence should include witness statements and screenshots of the online libel. The evidence should be as complete as possible because it must hurdle probable cause. If it hurdles probable cause, the prosecutor's office will forward the case to the court through a document called information. The court handling the case will also then make its own determination of probable cause. If it finds that there is probable cause, it will issue a warrant of arrest for the accused. The accused may post bail. If he does not post bail, he spends the duration of the trial period in bail. The court trial will then begin.